Good afternoon and welcome to the Law and Crime Network. I'm Angelica Spanos. Thanks for joining us today. We're following the live trial right now of Nicole Nachtman in Florida. She's accused of killing her mother and stepfather, and she even confessed to killing them, but claimed to hear voices telling her to do so. She left school and went to her mother's house to find her mom and stepfather. That is where she killed them. The defense here is claiming insanity. And right now, happening live, the attorneys are proffering a witness outside of the presence of the jury. I'm told that the witness is the defendant's biological father. So let's go there live. All right, so we just heard live an argument really going on about if Nicole's biological father should be able to testify. We did hear from him previously, but he was not allowed to talk about any physical abuse in this instance. Joining me today to break all of this down is Randy Zelin, criminal defense attorney, as well as Ashley McMahon, criminal defense attorney. Thank you both for joining us today.
Hi.
Thanks for having us.
All right, so while this proffer just went on and what we just heard here, why did that go down and what was the purpose of all of that?
Generally speaking, a judge has to walk a tightrope in a situation like this. You have two competing interests. You've got the probative value of testimony. In other words, is it testimony that will be helpful to let the jury reach their conclusion of guilt or lack of guilt? And oftentimes that has to be balanced against what we call the prejudicial effect that the testimony could have. So it seems as if the state was arguing that allowing the father to testify about abuse, apparently, that maybe he suffered or he suffered while he was holding Nicole, that should be brought to the jury's attention, that the jury should be allowed to know about that, and the defense argue that that is probative. In other words, it's relevant. It goes to an issue in the case, and it goes to something that the jury is considering as to their findings. The state argues, no, wait a minute. That's way too prejudicial. It really isn't relevant, and it is going to screw the jury up. They're going to be focusing on issues that they shouldn't be focusing in on, and it's unfair. And it sounds as if the judge made the determination that with regard to allowing that testimony, that the prejudice outweighed the probative value, and that this witness would not be allowed to testify about the physical abuse.
So basically, the original standing stands that he can't mention the physical abuse.
That's correct.
But the defense, or the prosecution, sorry, wanted to change that, and it did not work.
Well,
I'm just trying to get layman's terms here.
In layman's terms, it sounds as if the defense wanted the biological father to be able to testify in front of the jury about the physical abuse. It sounds like that he suffered apparently while holding Nicole as an infant. The state said no, that's way too prejudicial, and the jury should not be allowed to hear that. And it really doesn't go to the heart of the case. And it sounds like the judge agreed with the prosecution and said, you're right, the prejudice that the effect that it will have on the jury, the prejudicial effect on the jury outweighs whatever, again, the relevance, wherever the defense may say, no, that goes to an issue of our defense and the jury should be allowed to hear it. The judge agreed with the prosecution.
All right, Randy, thank you. We have some clips from when her biological father did talk about this abuse prior to this. Let's play you those. All right, so again, that was Ronald Nachtman, who's Nicole's biological father, and he was the defense's second witness here. This is his testimony from Tuesday. Ashley, let me bring you in to weigh in on all this. What do you think of his testimony there now that we know that there have been, these back and forths to allow him to testify again?
Angelica, I think his testimony is just absolutely explosive, and I think Randy did an amazing job of explaining what the prosecution is trying to keep out here and what the defense is trying to get in. Obviously, it'd be great for the defense's case if they were allowed for him to testify and his testimony to come in about all of the abuse that not only his daughter suffered, but that he was suffering as well, even prior to her being born. But we saw in those clips how the state kept objecting to relevance. Every time he was saying, I was repeatedly being punched in the head, they objected to relevance because the fact that he was abused or he was being hit isn't necessarily about how his daughter would have turned out and about the abuse challenges that her defense team is making. But what's also important here is that the defense got to make what is called a proffer. So they had him testify outside of the presence of the jury and just in front of the judge. And this allows his testimony, even though the judge decided that it is not relevant and it is not coming in and it's too prejudicial, that allows his testimony to go on the record. So if there is an appeal in this case, and oftentimes in cases of this magnitude, there will be, the defense is doing their job of preserving that evidence. And so they'll have it on the record that this is what he would have testified to. It could potentially change the outcome of this trial at a later date. And this is the judge's ruling. And then an appellate court might be able to say, hey, the judge was incorrect in their ruling in not allowing this testimony in. So the defense is doing a great job of making sure that they're crossing all their T's and they're dotting all of their I's in this case, just in case something comes up and an appeal comes up later. And that's something you got to be thinking about in addition to trying to win this trial for your client. So I think they're doing a great job.
All right, Ashley, thank you. And Randy, what do you think about that now that you've seen the proffer and heard his testimony from a couple days ago?
I think that there are a couple of things that immediately are starting to resonate with me. First of all, I will throw the compliment right back at Ashley. She did an equally great job on explaining an often overlooked thing that goes on in a trial, which is preserving the record for appeal. In fact, there are times you will do things knowing you're not going to win the argument in front of the judge, but you can never be afraid to open your mouth, because if it's not on the record, the appellate court, the higher court that you're asking to look at an issue, if you want a do-over, for example, they will say, I'm really sorry. It's not preserved. You didn't preserve it for purposes of the record. So you make that proffer even if you know you're going to lose. So this way, it's there for the appellate court. But I'll tell you what is starting to happen to me and what I'm seeing here. First of all, it's always very dangerous when the defense dumps on the victim. It's a very, very dangerous road, particularly when the victim is deceased, let alone one's own mother. It is dangerous because this witness does not have the ability to defend herself. She's dead, and she truly is the victim. So you have to be very careful when you want to make it, let's blame the victim, or you take a dump, or you take a crap on a victim, particularly, again, when it's your own mother who you're accusing of killing. And then you're starting to see these almost throw it up against the wall. Well, maybe I was insane. And if I wasn't insane, maybe I was battered and I acted in self-defense. That, too, you run the risk of a jury saying, hey, wait a minute. Let's kind of make up our minds here. What do you think you're trying to do? So I would be careful if I'm the defense, unless they're trying this case for an appeal, as Ashley indicated, and sometimes you do that. Let's hope I get a do-over from the higher court.
All right, thank you so much. We have to take a quick break. When we come back, though, we'll continue to follow this trial live. Stay with us.